Et ben voilà, nous avons la tâche de terminer cette belle journée d'hommage à Emmanuel. On a pensé à vous donner un aperçu dans le même esprit de ce qui vient d'être fait par Pierre et nos collègues sur le précédent panel. On a pensé à vous exposer l'influence d'Emmanuel sur le droit de l'arbitrage en matière d'investissement, mais de le faire un peu sous forme de débat, de discussion entre nous, comme c'est la fin de la journée. Ça mettra un peu plus de rythme pour finir cette journée. Je commencerai juste par dire que je suis ici, j'ai le plaisir de modérer ce panel au nom de l'IAI, l'Institut pour l'arbitrage international, que j'ai l'honneur de présider dorénavant en remplacement d'Emmanuel, mais on ne peut pas remplacer Emmanuel, je ne peux que poursuivre son chemin et la voie qu'il a tracée, avec des travaux scientifiques à venir qui seront passionnants. Je serai en contact avec tous les membres de l'IAI dans les semaines qui viennent pour vous dire un peu les beaux travaux qui nous attendent, encore une fois, pour poursuivre aussi ces éléments de réflexion et encore d'autres. Deuxième point que je voulais faire, c'était de parler du fait qu'on va parler en anglais. C'est un panel qui va être en anglais parce qu'on a le plaisir d'avoir le professeur Andrea Bjorklund qui parle parfaitement français du reste, mais qui est anglophone, et on aura par Zoom le professeur Christophe Schroyer qui nous fait l'amitié de remplacer Michael Reisman qui ne pouvait pas se joindre à nous, mais qui voilà, est avec nous aujourd'hui pour discuter de tous ces thèmes. Et dernier point, et là je passe peut-être vers l'anglais pour tout de suite nous mettre dans le bain. It was a bit difficult trying to find a number of issues on which Emmanuel had an influence in investment arbitration. We discussed and we came up with 4, and we will discuss those 4. It doesn't mean that there's not other instances where Emmanuel had also a very important influence. I just want to say a couple of words on the topics we will not touch upon. And Anna Jubambreit this morning discussed the parallel proceedings and concurrent proceedings and Emmanuel's influence on the works of Institut. That is something that Emmanuel has worked a lot on and written a lot on, and that is one of the important issues on which he has had an influence. He also had a very important influence on issues of corruption, as you may know, and this goes to our discussion on substantive rules of international arbitration, the scope of illegality, the role of international law, especially in the exit system, and temporal application of treaties. And these are just examples of where Emmanuel had an influence, and I just wanted to put a marker on those issues. The 4 issues that we will discuss, we will take about 15 minutes for each of those 4, and then having a debate among ourselves. And for each topic, there will be one discussant who will introduce the topic. I will say just a few words of introduction, and then we will have a debate on each of those 4. So without further ado, I will start with, you will not be surprised by the notion of investment. And this is really key in international investment law, of course, in the exit system in particular, and the very famous Cellini test about how investment should be defined. And as Professor Kaufmann-Kohler, who has really made us the friendship of coming and discussing the Cellini test is based on Emmanuel's writing and thinking and the economic notion of what an investment is. So Gabrielle, thank you very much.
Thank you, yes. Actually, before going into the notion of investment, I thought I should say, speaking of investment arbitration and Emmanuel, I remember well when more than 35 years ago, I read Emmanuel's first chronique in the Clunet about exit arbitration. I covered the years 65 to 85. There were then 5 awards on the merits had been rendered, and only 4 were known. And I was thinking, well, why does Emmanuel devote that much effort to this completely largely unknown mechanism? Obviously, like always, he had grasped quickly the huge potential of investment arbitration and the rest of the evolution did show that he was right. Now to the notion of investment. When drawing up the Salini test, the arbitral tribunal in Salini, Morocco, listed 3 components of the economic notion of investment. You know them well: contribution, duration, and risk. And it added, just after these 2 notions, a reference to Emmanuel's commentary on FedEx versus Venezuela in the Chronique of the Clunet. And Emmanuel wrote there, 3 éléments sont donc requis: l'apport, la durée et le fait que l'investissement supporte, ou au moins en partie, les aléas de l'entreprise. And then, somewhat unfortunately, in my view, the Salini Tribunal continued in reading the preamble, meaning the preamble of the Exit Convention. One may add the contribution to the economic development of the host state of the investment as an additional condition. In 2009, Emmanuel has well shown that in an article that the Salini test actually merged 2 fundamentally diverging approaches. First, one that he called deductive, setting out cumulative criteria of the economic notion of investment, which was precisely commitment of resources, duration, risk. Sometimes you can also say expectation of profits, but that goes with risk. And the second approach was a more flexible one that he called intuitive, that was traced back to Delorme's writing. Delorme was the legal counsel of the World Bank at the time of the Exit Convention, that relied more on typical characteristics of investment without formal requirements, and essentially derived from the preamble and from the purpose of developing the host state economy. And Emmanuel himself was obviously a firm proponent of the deductive method. It can be seen from later awards, for instance, from Leslie de Benta or from Pei-Casado, where he was a co-arbitrator, and more so from Sabafakis versus Turkey, which he chaired. The cases have gone both ways, with a prevalence for the deductive method. Among those accepting the deductive method, you have some that use 4 conditions that add to the 3 requirements, the development of the host state, and then you have others that adopt just 3 conditions, and more recently this seems to be the majority. Interestingly, looking further to the evolution, a number of recent treaties list the 3 conditions of the deductive methods as conditions of investment before giving then what I call the laundry list of assets. CETA, of course, is one of the prominent examples: commitment of resources, duration, risk, or expectation of profits. Does it list? The Dutch model, BIT, has the same enumeration. I could add others. There are others, but that's not the purpose here. And that shows well that the economic notion of investment that Emmanuel advocated prior to the Salini test, that has evolved throughout and seems now very much accepted standard.
Thank you, Gabrielle. And so now we'll just have a short discussion on this topic, and started with Christophe, who will be joining us by Zoom. We hear you now, Christophe. Please go ahead.
Okay, very good. What I find most interesting about the Salini test is that everybody invokes it but there seem to be widely diverse ideas as to what its meaning is, namely what its significance is. Some people say that it's an jurisdictional requirement, and that would of course be Emmanuel's deductive method. Other people just call it a feature or characteristics, hallmarks. So my impression very often is that tribunals don't want to pin themselves down as to what it's supposed to be. They just apply it and say, well, whatever it is, this particular transaction meets the criteria of the Salini test. That's one remark I wanted to make. Another remark I wanted to make is that in the report of the executive directors, you will find a rather odd sentence. It says, no attempt was made to define investment. That is odd because it's simply untrue. If you look at the travaux préparatoires to the ICSID convention, you will see that lots of attempts were made, but they all failed in the end. And in the end, well, it was probably Aaron Broches who threw up his hands and said, okay, we can't reach an agreement here, and we don't really need it, because what matters is what the parties consider to be an investment, and that would probably be clear from their consent agreement. But of course, one of the problems is, if we look at BITs, the descriptions of investments are so wide that you do need an objective containment of the concept of investment, because if you have a phrase like any claim to money or to performance, that is so wide that a metro ticket would amount to an investment, and that obviously cannot be true. And the last word is that the strictures of the Salini test, to some extent, I think, are mitigated by the concept of the unity of the investment. Tribunals have developed the concept of the unity of the investment, and that means that you don't look at individual transactions, you look at the sum of the various transactions that an investor made in a particular country. You look at them collectively and decide whether that is an investment. For instance, it could be a series of contracts where the individual contract obviously is not an investment. The individual sales contract is not an investment, but in the aggregate of these contracts are an investment. Okay, let me pass on now.
Thank you, Christophe. And maybe moving on to Andrea.
Thank you very much, Yaz. It's a great pleasure to be here, and it's nice to see all of you. When one talks about investment and the attempts usually deficient to define investment in investment treaties, as Gabrielle has noted, you often have a laundry list of items without much more, or even worse, you have a circular definition, which my favorite, which is an investment means every kind of investment, something that kindergartners are taught is inaccurate and not the way to define anything. But I'm also reminded of what Justice Powell used to talk about in U.S. courts about what pornography was. We couldn't define it, but we knew it when we saw it. And I think that we see that a lot with the definition of investment prior to and even post Emmanuel's writing and post Salini. And I think that really captures the distinction between the kind of the intuitive method and the deductive method of whether we just know it when we see it, we know what we think an investment is. We all have ideas about what the quintessential investment is. And then the more difficult questions are when, I don't know, maybe you don't have all of those characteristics, or they don't all exist in exactly the way that you would traditionally have seen them, so that your instincts are inadequate in order to ascertain what you're talking about. So I guess I think it's terrifically important, and we see, as Gabrielle mentioned in CETA, finally states really taking on board a more sophisticated attempt to define investment that goes beyond an investment is something that has the characteristics of an investment to include the so-called Cellini criteria. So I think it's important and useful to see the spread of these ideas, even if now, some 20 years, almost 20 years after Cellini, sometimes the source is not always recognized.
Thank you. Julien?
Yes, thank you. I think I will disclose first that I was counsel in the Sabafakis case, and it was the first time I pleaded in front of Emmanuel. And I think not many have given that much credit to that decision, which is actually one that I always use with students. For one reason is that it captures in 20 paragraphs Emmanuel's thought about what an investment should be. And in the article you co-wrote with him, Yas, it reasserts exactly the same thing. So if there was no jurisprudence constant in terms of investment, Emmanuel's thought about investment has always been constant. And I think for those who haven't read it, I really encourage you to read it. It starts at paragraph 96, and I reread it recently, and it's 20 paragraphs, and it's crystal clear about the fact that he had no doubts about those criteria, and explaining very clearly why it was so difficult for tribunal to depart from Cellini, because actually it was impossible to depart from it, because it was so crystal clear that that economic definition and the criteria it gave was necessarily what an investment should be. And I think on top of that, he added something that not many people actually address, is the fact that when you talk also about illegality, when you talk about all those issues that go around the investment, he always said that even if the investment is illegal, it's still an investment. And not so many people are actually making that distinction. It doesn't mean that that investment will be protected, but it doesn't mean that it's not an investment. And I think it's something that is sometimes not addressed too much in many writings, but I think it's fundamental, and I think, again, Emmanuel made it very clear in most of his writings and in the awards.
Thank you, Julien. And it is important to underline Emmanuel's courage in saying that, because it was not necessarily politically correct to say that, but to make the distinction between protected investment and legal or illegal. And one of the important, and I agree with you that Sabafakis is a great decision also because it designs the scope of illegality that an arbitrator has to look at when discussing illegality issues, and that's one of the major cases on the topic as well. And
if I will cite five lines about that, because I think it's very interesting, and I think it was quite courageous to say that. And in that award, it says that an investment might be legal or illegal, made in good faith or not, it nonetheless remains an investment. The expressions legal investments or investment made in good faith are not pleonasms, and the expressions illegal investments or investment made in bad faith are not oxymorons. And for me, it's very, and as a teaching method, it's very interesting to show that to students, to make them understand that investment is first economical construct or an economical instrument, and then you have the legal construct that comes after that. And it's not the reverse.
Thank you. That was perfectly clear. Thank you very much. And we're moving to the second topic that we are going to discuss, where Emmanuel had a quite important influence, and that is the notion of umbrella clause. How this all started, and maybe an anecdote. And you are, of course, or those of you who have studied investment arbitration are familiar with the notion of umbrella clause or undertaking, observance of undertaking, and the number of ways in which we can refer to those clauses. Emmanuel actually liked to say observance of undertaking, because this is the more legal way of referring to it. It all started in SGS versus Pakistan and SGS versus Philippines. These are two cases well known where the concept was discussed for the first time, where Emmanuel raised it, and he really found it in the treaty. This was in the Swiss model, where we had this provision which said that the contracting parties undertake to respect the commitments they have made otherwise. So the point was, what does this mean? And I remember that was the day Emmanuel was actually preparing for a hearing. I was called on a rush basis to his office, and then he said, you know treaty law, let's discuss this. And we discussed how this should be read and what is the meaning of that. And then the next day, of course, he was before the tribunal and argued this. And what you know is now history, how this has been developed before the SGS Pakistan and SGS Philippine tribunals and a number of other tribunals as well. So he really was the first to notice the provision, to find a meaning to it and to argue it. The Swiss government, in fact, also made a note of it, and that was published after we actually lost on what that meant in SGS Pakistan, and the Swiss government was not happy about it. And so this is just an introduction with an anecdote, but I will now pass on back to you, Christophe, to just maybe explain what the umbrella clause is, and then we'll go around again for a very short discussion. Christophe?
Yes, thank you. Well, as you pointed out, it's a clause in a treaty that essentially says that the state will honor its undertakings towards the investor, whatever undertakings means. I'll get back to that in a moment. But the interesting issue is that umbrella clauses had been around for a long time before SGS versus Pakistan and Philippines. In fact, almost 50 years. You will find an umbrella clause in the very first bit between Germany and Pakistan of 1959, but it doesn't appear in all bits and doesn't appear in all treaties. You will find it in the Energy Charter Treaty and in many bilateral treaties, but not in other treaties. There is no umbrella clause in the NAFTA, nor in the USMCA, nor in CETA. So until 2003, it was a sleeping beauty, and I think it was Emmanuel who, in a sense, kissed it awake through his pleadings in SGS versus Pakistan and SGS versus Philippines. The irony of the story, of course, is that he wasn't successful in SGS versus Pakistan. His ideas were too revolutionary, in a sense, too novel for the tribunal, and the tribunal came up with a number of reasons why they wouldn't apply it, why they wouldn't buy Emmanuel's arguments. If somebody states several reasons, there's always a suspicion that none of them is really very sound, and I think that was actually the case in SGS versus Pakistan. Now, shortly thereafter, in a similar case, SGS versus Philippines, the tribunal did accept Emmanuel's arguments, and it said the umbrella clause means what it says, that the host state must honor its undertakings. In that case, it was contracts. But alas, tribunal didn't carry it to its logical conclusion. In the end, it dismissed the claims based on the umbrella clause because of a forum selection clause in the contract. So although Emmanuel was not successful in these early cases, he put the umbrella clause into the center of attention, and he started a development that has been of utmost importance ever since. Many tribunals have since applied the umbrella clause, finding that a breach of contract amounted to a breach of treaty. There's a whole series of cases that say that. However, this was not an unqualified victory, because tribunals over the years have come up with a number of limitations. For instance, they would say, well, it only applies to certain agreements, only to agreements that have been entered into by the state in its sovereign capacity, like the French contrat administratif. Or they would say, it only applies to governmental interferences with an agreement. That's another limitation. Then there is the problem of privity. Some tribunals have said you can only apply an umbrella clause if there is a direct agreement between the state and the foreign investor, and not with the investor subsidiary, or not by an entity of the state. And there's been a debate as to whether umbrella clauses only apply to contracts or also to unilateral undertakings, although that, of course, depends to a very large extent on the exact wording of the umbrella clause. I think I'll stop here and pass on.
Thank you, Christophe. Thank you very much. The next discussant is Gabrielle. And Gabrielle, Emmanuel referred to your case law, which he completely endorsed on the umbrella clause, and he liked to refer to your case law as the it factor. I don't know if this is what you're going to discuss, but I pass it over to you.
No, I never discuss my case law. That I leave to others. I write the case and they can criticize it. No, I respectfully disagree with Christophe when he says that Emmanuel's ideas when he pleaded SGS Pakistan were novel. Actually, if you look at the history of the umbrella clause, if you look at writings of Elie Lauterpacht, if you look at writings of Prosper Weil, this was the logical explanation that he brought forward. And it was somehow disappointing to have the tribunal considering for reasons that do not look very persuasive that this should not succeed. But more than about umbrella clause, what strikes me here, speaking of Emmanuel's contribution, is that here he was first involved as a practitioner, and he faced a new issue as a practitioner. And then, even though he lost in different ways in both cases, he took it further and theorized, théorisé, the issue in an article that then delineated the three possible approaches. Either the contract is converted into a treaty obligation, or it is not converted, or it is converted but there is an exclusive choice of forum clause in the contract, and that brings to a stay, which is the solution in SGS Philippines. So to me, it's the working method, if I can say so, of Emmanuel that is particularly striking in him. On the one hand, being a practitioner, and then drawing as a scholar the lessons from the practice in a perfect combination of practice and theory, I would say.
Thank you, Gabrielle. Andrea?
Yes, this is to follow on what Julien did last time. I use Emmanuel's article to teach the umbrella clause, his article in which the book chapter in which he compares SGS versus Pakistan and SGS versus Philippines in particular, and of course in particular what in his view they got wrong. But it's such a clear exposition of the three potential approaches and the pros and cons of each. Of course, one of the things that the SGS cases did very early on was to establish something of a divergence, a fulcrum for criticism of investment arbitration with inconsistent decisions. And indeed, other investment clause decisions have, in a sense, contributed to that. Not through anybody's fault, but because there have been different conceptions about what they mean. The other thing that he pointed out very clearly in that article was the asymmetry between the litigants, where you had the claimant not having access to the travaux préparatoires and not having, you could say, knowledge, let's say, at the time of the dispute about what Switzerland had intended, or, sorry, Christophe, what Switzerland's objective intent as it exemplified in the treaty was with respect to the umbrella clause. And that is a kind of a recurrent theme in a lot of investment cases. And he also, proposed the solution, which should, one thinks, have been obvious, that perhaps the tribunal could have inquired of the Swiss government if it wanted to opine about its view of the clause, if the tribunal were going to actually rest its decision on this supposed shared intent.
Thank you. Julien?
Yeah, I think just 1 or 2 points, because I think most of it has been covered. I think it's also, in this instance, as much as with investment we've just discussed, Emmanuel trying to also express the fact that tribunals and commentators should not add conditions when they were not there. And thinking about that, I think about the fact that many have raised the issue that we should only use umbrella clauses when it's flagrant violations or something extremely important. And if you look at the Chronique du Clunet in 2007, where he discussed some of these issues, it's very interesting because he makes a point saying that he was disappointed. You could read between the lines that he was disappointed or thought that the decision, notably in SGS Pakistan, was severe, but that seeking the real intention of the contracting state was not questionable. And it goes to Andrea's point, is the fact that maybe the tribunal should have asked the states its views to understand better. But for the issue of transforming a breach of contract into a breach of treaty, for Emmanuel, at least in what he wrote about it, it didn't make any sense to say that it would only be for big violations, because basically Emmanuel explained that it was precisely the state's wishes that investment disputes, no matter what, should be resolved in neutral forums with arbitral tribunals, regardless of the importance of the violation or of the underlying contract. And adding a condition like adding, let's say, the condition that we've mentioned about investment on top of it would just prevent some parties to have access to that neutral forum, and that was not acceptable, and that was not necessarily, and probably not at all, what states meant when they included those clauses.
Thank you, Julien. If I may add a few comments of myself on this topic. The first is that Emmanuel was not happy indeed when we didn't win SGS Pakistan, because the tribunal simply didn't understand what this meant, posed a number of conditions for the clause to be effective, whereas in SGS Philippines, we won completely in the sense of the meaning that was given to the provision, where the tribunal consisted of Judge Feliciano, James Crawford. It was a prestigious tribunal. The tribunal did understand what it was and actually said, and it's a very good reasoning on how umbrella clauses should be understood. The only problem, as Gabrielle mentioned, is that then the tribunal stopped short and sent back to the Philippine courts, which to us was, in effect, a negative excess of powers, because if you declare that you have jurisdiction, you have to go all the way and actually exercise that jurisdiction, which that tribunal didn't do. We never actually got to the point where we challenged the award because there was a settlement at the end, but this was really the issue there. On the Swiss issue, there was, at the time of the arbitration, the question of whether or not Switzerland should come and intervene in relation to the interpretation of the treaty. Switzerland didn't want to do that at the time, but then once the decision was rendered and we didn't prevail, Switzerland was not happy, and that's where we had this 3-4-page letter to exit where Switzerland said, this is not what we meant. Our intention was exactly how it was argued by the claimant SGS, and this tribunal got it wrong. That, in fact, was one of the reasons why when the ancestral works started in relation to transparency before we got to the Mauritius rules and the Mauritius Convention, we made a suggestion to ancestral that we should have a intervention by the home state that should be allowed precisely for issues of interpretation of treaties, because then you have a better playing field, more leveled, so that the investor can benefit from the interpretation of treaty as the home state has it, because the home state knows what it meant when it went into that treaty. The second point I wanted to make was the it factor. I will say it. It's about the important case law that says it's privity. It's the fact that it has to be a commitment that the state itself made. You cannot use rules of attribution and say this is a state-owned company that made a commitment and therefore that's the state. It doesn't work that way, and that it factor is it, the commitment that it made, the state. So that's important enough to underline. And then the last point is really, as Gabrielle mentioned, this was really Emmanuel's influence as an advocate. And this we will see, and as we discuss, how Emmanuel had an influence as an advocate, as a scholar, as an arbitrator in Sabafakis, So we do see all of these hats that Emmanuel had in his influence on the topic. So my next topic is precisely one where Emmanuel started out as a scholar. We discussed it this morning. This was at the inaugural lecture of the Academy. I think it was in 2015. I think this is what was said this morning, where Emmanuel discussed his, marvelous article, which then became an article, but the inaugural lecture about abuse of process. And there was a great analysis of comparative law, and Emmanuel was a comparatist, comparative law between French rules, English rules, and how you can sanction in international arbitration abuse of process, abuse of rights. So that was the start. He started with his writing, and then we did argue that, and Emmanuel argued that. And in the book of Tribute to Emmanuel, you will see comments about Emmanuel's oral argument at the end, which was, I believe, having seen a number of other arguments by Emmanuel, and I think that a number of us, Benjamin is here, we believe that this was literally the most brilliant and fascinating oral argument we heard of Emmanuel, and God knows that there was a number of them. So that was the Orascon versus Algeria case, which Gabrielle will not discuss because she was the chair in that case. She will discuss other things. But I will now pass on to Andrea to explain abuse of process, and then we'll go for another round. Thank you.
Thank you, Yaz. Yes, so I highly recommend Emmanuel's article in the ICSID review. The definition he gives of abusive process is kind of a little bit twofold, but it's the exercise of a right for a purpose other than that for which it was established. And with a kind of a correlative reference to abuse, to the notion that you're trying to harm another without obtaining an advantage for yourself. And I've made a little note, aside from Schadenfreude, aside from the satisfaction that you're causing harm to somebody else, but you're not actually even gaining necessarily that big a benefit to yourself always. So his notion of abusive process is that it is useful when you have behavior that is prima facie legal. There's nothing actually unlawful about what is being done, at least in black letter terms, and that means it cannot be redressed through the application of black letter rules. I think he also made the kind of important exclusionary point that not every abusive act is an abusive process. So the large dump of documents on the eve of a hearing might be a violation of due process. It's not necessarily an abusive process, even if it is behavior to be discouraged. The refusal to honor a valid arbitration agreement might be a breach of contract. It's not necessarily an abusive process. And I think you see the importance he attaches to categorizing things properly so as not to muddle up these categories. But he really gave a nice typology of situations in which you frequently see abuse of process. One was at the jurisdictional stage, particularly in investment arbitration with the various machinations used by investors to secure jurisdiction under an investment treaty. Here again, he distinguished between abusive process, again, the lawful, perhaps, structuring of an investment, but done with the knowledge that a dispute has either crystallized or is about to be crystallized, so that the purpose of the structuring is to submit the claim that is already known about. Versus what he called pure fraud, the situation where you actually fraudulently make the investment kind of in the first place. I thought that was quite interesting. The second set of areas that he addressed was the multiplication of arbitral proceedings to maximize chances of success. And I'll talk about this a little bit more in Orascom, but the notion that you actually submit the claim, that a claimant submits the same claim multiple times in order to, if you will, have 3 chances or 4 chances of convincing a different tribunal that the claim should warrant redress. And the third example was the gaining a benefit inconsistent with the purpose of resolving the dispute, with the primary example given as one where the purpose of submitting a case is to really gain media attention and to not even really try the case in the media, but to bring the existence of the case or the existence of the quasi-dispute to the media in order to try to foment some other kind of resolution. You know, he described these as happening in both commercial and investment arbitrations, and the focus of his article was really on claimants. As I was reading it, it occurred to me that you can see some of these examples on the part of respondents as well. Potentially that there's an inverse to most of these. So you have frequently jurisdictional objections made by states, which are sometimes relatively clearly not valid, even from relatively clear from the get-go that they're not valid. You can also have situations, I was thinking about respondents seeking, you know, arguing, looking at different tribunals, but arguing forum non-conveniens in one forum and then getting to the other forum and then seeking dismissal because of the inadequacy of the forum. And certainly in various cases, respondents have also tried to use the media in order to further their case. But in any event, he also highlighted the paucity of tools available to fight these abuses. There's some power to allocate costs and potentially to limit damages recovery, but he found those inadequate given the multiplication of chances that accompanied the ability to submit multiple claims. Lease pendens and res judicata are often insufficient because of the formality of both cases that don't capture all of the problems. And so he really thought that the abuse of rights principle as a general principle of law would be both important and beneficial for arbitral tribunals to use. And so there we see, as Yaz mentioned, kind of a law in practice example of his theory. And certainly this is true in the Orascom versus Algeria case. This was a case involving abuse of process of the second type, a multiplicity of proceedings, where you had 3 different bid proceedings brought by a vertically integrated set of claimants. In Orascom, that particular case was the claimant at the top. There had already been a couple of other proceedings submitted. And the really key, I mean, this was a fact-specific case, as they all are, but the key issue was that you needed to succeed. The claimants in all of these cases needed to succeed only once for the harm to be remedied. And so the tribunal dismissed the case for lack of admissibility on grounds of abuse of process, and in particular noted the risks of multiple recoveries, conflicting decisions, and the waste of resources in multiple proceedings, which was all harmful given that the investment was already protected and a claim had already been brought. So I will stop there and let others comment as well.
Thank you. Christophe, your turn.
Use of process is probably a general principle of law, and it has almost infinite possibilities for application. In investment arbitration, as Emmanuel so ably set out in his article, it appears primarily in 2 forms, namely manipulative nationality planning, where you change your nationality to gain access after a dispute has become apparent, and in the multiple proceeding situation, like in Orascom. However, there may well be other situations where this can play a useful role. For instance, and I think Emmanuel mentioned that in his article, for instance, proceedings instituted solely for the purpose of putting pressure on the state, or another one that happens sometimes in commercial arbitration, I understand, and that is money laundering, where you conduct an arbitration for the simple purpose of money laundering, where you have a conspiracy between claimant and respondent. Then I believe there are also various guerrilla tactics during proceedings which can be described as abuse of process. In some cases you find repeated objections to jurisdiction in the course of the proceedings by the respondent. So abusive process is not reserved to claimants. It can occur on both sides. Or another guerrilla tactic that you find quite often is vexatious document production requests, or the opposite, flooding the tribunal with an overabundance of more or less relevant documents. I think Jas mentioned the idea of seeking the opinion of the other treaty partner, the non-disputing treaty partner. Now, I think that's a coin that has two sides. I'm not sure if that is always such a welcome development. In recent cases, and I've seen this in a number of cases, the home states of the claimants would make non-disputing party submissions, interestingly, almost invariably to the detriment of their own nationals. In other words, you find, all of a sudden you find agreement between the two treaty partners. In other words, the home state sides with the host states. And then the interesting question arises in the sense of Article 31.3 of the Vienna Convention on the Law of Treaties. Is that a subsequent agreement between the parties? Or is it at least subsequent practice? Or is it an abuse to move the goalpost, so to speak, in the middle of the game? Incidentally, the new rules, the new ICSID arbitration rules, foresee compulsory admission, compulsory from the perspective of the tribunal, of non-disputing treaty party submissions. So they have to be admitted. So this is going to add an interesting new dimension to investment arbitration in the future, I believe. Let me just make one more point. There are also instances of unsuccessful invocations of abuse of rights. Let me give you two examples. Respondents have sometimes argued that a nationality must be effective in order to be able to, in order for the claimant to be able to rely on it. Another argument has been also unsuccessful, that the origin of funds must be directly from the claimant, or at least from the claimant's country. Both of these theories have been rejected, but they ultimately were based on an argument that what the claimants did, namely rely on a formal, only formal nationality, or use other people's borrowed money, was an abusive process. In fact, Tokios Tokeles, I think, is the best example for both of these arguments. Thank you.
Thank you, Christophe. This does raise the issue of the threshold, right, of abusive process, which is not a low threshold. Exactly, yes. May I just add,
the International Court of Justice has recently, in the immunities and criminal proceedings case in 2018, said explicitly that it would only apply under exceptional circumstances.
Thank you. Julien?
Yes, I think Emmanuel made it pretty clear that he was hoping, I mean, in his ICSID review article 2017, that new legal rule would progressively emerge to tackle abuse of process. But in the meantime, and I think it was also based on his view of the arbitral legal order, that it was on the arbitrator's side that solutions could be found, but that arbitrators should be particularly cautious when they tackle this issue. Because he indicated in that article that arbitrators could not be naive anymore because of some of the tactics that some of the parties were employing that were absolutely unacceptable. And in his opinion, and I will talk about Orascom now, he welcomed, of course, the Orascom decision, saying more or less that it reversed the existing case law, and in his opinion, it was better reasoned and more concerned about the discredit that could result for the investment arbitration system from not sanctioning deviant procedural conducts. And we go back to the arbitral legal order, which is we need to protect what we have and we need to ensure that the parties don't misuse it, and then we don't get criticism for the fact that parties that misuse it don't get sanctioned. And I think one of the quotes I like about him is from one of his articles that the article that he drafted at La Revue de l'Arbitrage, which is called Dialogue des ordres juridiques, ordre juridique arbitral et ordre juridique étatique, where he mentioned the Orascom case, and he puts it into context, and basically he says that you have to put it into context, and arbitrators have to put their decision into the context of the whole arbitration system to ensure that there is no abuse of process. And I will quote him, and he says, une telle sentence, so Orascom, est emblématique de l'aptitude des tribunaux arbitraux à mettre en œuvre le droit des investissements en tant que système et non à contempler leur saisine du point de vue isolé de l'instrument sur le fondement duquel ils sont saisis, comme si cet instrument existait dans un vide juridique total. And I think that's extremely important, at least from my reading of his abuse of process analysis, is the fact that one has to take a step back and look at it from the whole system perspective to ensure that, yeah, we don't get abused and arbitrators don't get abused as well.
Thank you, and you're quite right to insist on Emmanuel invoking the arbitral courage. It takes courage to dismiss a case for inadmissibility or lack of jurisdiction for abuse of process in the same way as it advocated sanction of corruption and lack of naivete by arbitrators. And this goes to your point and also and Jan's question earlier, who safeguards the system? Arbitrators are there to safeguard the system. Gabrielle, is there anything you wish to add?
No, I just, I won't, as I said, I won't comment Orascom, but carrying forward from what you're saying, I think when we speak here of abuse of process, we should really distinguish this with abusive conduct in the arbitration. This is abuse of process. It's not abuse in the process. It's abusing your right to arbitration. And the examples in the typology show it well, and also the example of what is not abuse of process, like filing too many documents a few days before the hearing, shows that this is not what we're speaking of. Here is a much more important step, which is starting the arbitration.
Thank you for this very important distinction.
And maybe one more thing which struck me when I read Emmanuel's article again. He stressed the difficulty, the challenges for tribunals of applying abuse of process, because it is not, as usually tribunals sanction violations of rules. This is not a violation. Yeah. This is the use of a right. And you cannot abuse a right if you do not have a right. So it's about how to use the right. And that is much more difficult to assess than just saying there is a rule and you breached the rule.
Thank you. Thank you very much. So now we are at our fourth and last topic. This goes to French law and arbitration. Surprisingly, you may know we discussed the Décret de 2011 earlier today. You may or may not know that Emmanuel advocated to the Minister of Justice when the law was being prepared. He advocated more transparency and a reversal of the assumption that arbitration should not be confidential by nature. And that was something that Emmanuel deeply believed in, which is that confidentiality is not necessarily intrinsic to arbitration and an attribute of arbitration. He advocated that because we have investment arbitration precisely, and because there's such a thirst for transparency, we have to evolve with society, we have to evolve with mentalities, and to recognize this need for transparency. And that was the basis for his thinking when he advocated and was followed by the Minister of Justice in France to reverse the assumption and to have in international arbitration transparency of arbitration unless the parties decide otherwise. So this is really what we want to discuss. Since it's French law, Julien, you'll start. And,
I'm the French, so I'll take it. So yeah, I went back a little bit into what Emmanuel had written, and you can see in writings since the 1990s and the 1996, because in the Fouchard-Gaillard-Goldman, that already admitted that confidentiality was seen as many as a fundamental principle or major advantage of international arbitration, but that it was not general, that some people viewed it and some people didn't, which bared as a conclusion that it was necessarily not a foundation principle of international arbitration. And he further stated that confidentiality was already in decline in '96, referring inter alia to ICSID's publications already at that time. And actually, it led Emmanuel to consider in 2003 that in an article that he published in the Revue de l'Arbitrage, that investment arbitration has now developed its own characteristics, including the weakening of confidentiality, and could and should actually have an influence on international arbitration in general. And in his writings, he highlighted that the fact that investment arbitration involves notably the responsibility of states have given rise to strong public or legitimate aspirations to know the outcome of the case, and that should not necessarily be different with many other types of arbitration. And I think if you look at the Lalive lecture in 2018, he pinpointed the fact that states' positions were evolving all the time on this point, and here he mentioned mainly the positions of states during the preparation of the Mauritius Convention of 2014, and notably the position of France, which had evolved from not wanting enhanced transparency to accepted it in order to avoid notably the rebuke of the international community with respect to arbitration. But, as Yves said, what is very important and what is fundamental, and I think which I probably hadn't grasped before we discussed it with Yves, is the fact that actually the choice of Emmanuel to, when he was discussing with the ministry the 2011 reform of the French law of arbitration, was the influence of, was trying to import what good investment arbitration had done in terms of transparency and to kill a mythical animal, which was arbitration, which was actually not very helpful for our practice. And Emmanuel explained that the French legislature had not considered appropriate to provide such a principle of confidentiality insofar as in investment arbitration, it was not anymore a concern, confidentiality, but rather transparency was a concern. And having worked with the drafter, he just indicated that the solution actually chosen in French law was not only based on transparency, but was rather on the principle of neutrality with respect to confidentiality. Simply, the party could choose, but confidentiality was not to be imposed, which I think is a very important distinction, because if you have confidentiality, you know that 95% of the people will not opt out. But if you have to opt in, you have to make a conscious decision to take it to a step further and actually accept. And I think what we see now as a movement, notably in ICC arbitration in terms of transparency and absence of confidentiality, has stemmed probably from the 2011. But I think two more points as to Emmanuel's visions in favor of more openness or transparency is both, and I think it goes back to his arbitral legal order, to create case law, jurisprudence, for people to understand it, but it's also based on fairness and due process. Indeed, when he wrote in the in 1996, in the traité de l'arbitrage, in the Fouchard-Gaillard-Goldman, he said that traditionnellement, on oppose l'idée même d'une jurisprudence arbitrale, le caractère confidentiel de l'arbitrage et donc des sentences qui en sont issues. L'objection est forte, mais non décisive. Il est vrai que si les sentences n'étaient pas connues, que des parties auxquelles elles sont destinées, elles ne pourraient constituer de véritables sources. On ne saurait revenir à l'archaïsme d'un, entre guillemets, droit des pontifes inconnu des destinataires des normes. And I think it's extremely interesting because it goes first to the issue of we need to create a body for that arbitrary legal order of case law so that we can rely upon and that it's open for everybody. And it goes back to a second and probably a consequential element, which is fairness and due process, where he mentioned in his chronique in 2006, when the ICSID rules were discussed in terms of the new amendments and the modification of the Article 48.4, where he said that basically the interest of the publication is not only for the arbitral case law, but it's also a matter of fairness and a matter of equality of arms. And I'm sorry, I will requote again what he said. He says, le caractère systématique de cette publication, so ICSID publication, permettra d'atténuer le déséquilibre créé par le fait que certains plaideurs disposaient de sentences non publiées, mais que les conseils expérimentés pouvaient connaître et pouvaient donc voter à titre de précédent, tandis que d'autres parties n'y avaient pas nécessairement accès. D'apparence modeste, cette modification devrait jouer un rôle important, tant pour assurer l'égalité des parties que pour contribuer au développement et à la connaissance d'une jurisprudence arbitrale cohérente. So in a nutshell, transparency as a tool and serving due process and ensuring the equality of arms in investment arbitration, in international arbitration, in French arbitration law in general, and thus establishing une jurisprudence arbitrale.
Merci Julien. Andrea?
Sure. Well, I completely agree with what you've said, Julien, about the importance of establishing an arbitral jurisprudence. And having just come from Vienna, where the Wismut is not happening because it was all online. But I'm just thinking of how much the CISG, the Vienna Sales Convention, has developed in large part because of the Wismut and the attempts by various people at PACE, at UNCITRAL, to publish cases, arbitral cases and judicial cases, to bring them together to all cases that address that are decided on the basis of the CISG, and I think that's been an enormous contribution to the case law of the CISG, and we certainly see that in investment arbitration. I think it's more than, obviously just creating an arbitral legal order. I think the transparency is instrumental to achieve other ends as well, not just transparency in and of itself, but one goal, I think, is accessibility, right? And that's where I think sometimes we've perhaps fallen short a little bit in trying to make international investment arbitration more accessible. You can put on the internet a 400-page decision. That doesn't mean that it's necessarily accessible to the general public or really comprehensible by anybody who is not kind of learned in the field. So I think that we can, I'd like to think we can continue moving in that direction of having more, I guess, true accessibility. But I also think transparency really facilitates accountability. And it facilitates accountability of arbitrators in terms of making decisions, knowing that lots of people are going to read them, criticize them, scrutinize every sentence, every comma. Attorneys in terms of the quality, the competence of the representation. Business leaders in terms of strategic decisions. All of that I think is relevant for both, in a way, commercial and investment arbitration. But then you have accountability kind of whom, but then accountability to whom. And there, of course, we do see in investment arbitration the really, I think, important notion that the public at large has a real interest in these cases, and that the, if you will, the tribunal, but also the litigants, the disputing parties, have a responsibility to the public at large in how the cases are decided. And to circle back to what Julien was saying about the development of jurisprudence, you could say that the College of International Lawyers is also interested in the development of international law in investment arbitration, because transparency in that regard has really contributed to the development of international legal principles such as abuse of process that we were discussing earlier. So I don't think it's a coincidence that I feel sometimes like all international lawyers are now interested in investment arbitration, even though in 2001, in 1999, when I started my career in investment arbitration, there might have been more than 5 cases, but there really weren't more than 10. And now that's very different, and certainly the number of people interested is very different as well. So,
thank you, Andrea. Gabrielle?
Yes, I think the importance of transparency for the evolution of the law, for the predictability of the outcomes, for the certainty of the law in the end has already been stressed. Also, the link between transparency and accountability. I will just add the link between transparency and legitimacy. I mean, transparency is a principle of democratic governance. Arbitral tribunals are not public authorities, admitted, although in investment arbitration, because of the involvement of a state as sovereign, because of the arbitrator's mission, which is to rule on the international responsibility of a state with consequences on the fiscal resources of states, arbitral power comes very close to the power of a public authority. And we do know, at least as a matter of perception, and in the end what counts in terms of legitimacy is perception. And as a tool to improve this perception, it is clear that transparency is powerful. And in that sense, the idea of introducing neutrality in the 2011 decree was entirely in line with this concern of improving the legitimacy of the investment arbitration system.
Thank you very much. Christophe, we'll finish with you.
I think we all agreed that we're in favor of transparency. There's no doubt about it, and that we want as much transparency as possible. But I think we should still remain aware of the fact that it is a relative concept, not an absolute concept, and that different issues must be treated differently, with some differentiation. Let me list you a few issues that may require different treatment. The first question is, should there be publication of the existence of a case? Second, should there be publication of the awards? Should there be publication of other decisions and attendant documents? Should the hearings be open to the public? Should the pleadings be published? Should the transcripts be published? So far, I think you would probably say yes to all of these. But then there are areas where clearly we favor confidentiality over transparency. Deliberations of the tribunals, obviously, that's not something for transparency. That is something that's confidential. Or the attorney-client privilege. So there are areas that remain confidential and I believe must remain confidential. The differentiated way in which these various issues must be treated is also borne out by the new ICSID rules, which give differentiated answers to all the issues that I've listed just a moment ago. A final word. Lack of transparency has been a major point of criticism against investment arbitration. I think one answer nowadays is that in many cases, investment arbitration cases are more transparent than most cases before domestic courts. Where do you find a system that publishes so much, including party pleadings and so forth? Although, of course, this is not uniform, and there are still some cases, some proceedings that are anything but transparent. Thank you.
Thank you very much, Christophe. I'm very conscious of the late hour. We still have a few things to say on this panel, but since we have the luxury of having a very prestigious panel, I want to make sure that there's questions. If there's questions, they're all here to respond. So before we go back and finish, I would like to see if there's any question. Jan, you may start. It's coming.
I just want to contribute a little observation on this last one on confidentiality, which is interesting specifically to Gaillard's work in the 2011 decree. At the same time, while the decree was being elaborated, the European Commission had, of course, submitted its draft regulation on the grandfathering of the member states of the BITs of the member states, and in that context, it was actually me who raised the issue with the European Parliament that the confidentiality of arbitral proceedings as a hindrance to a member state informing the European Commission about the ongoing proceedings would be for the Commission a ground for ultimately terminating a BIT or asking a member state to terminate its BIT, which raised quite a lot of discussions in 2010 in the European Parliament, and I happen to know that that was something which also came to Emmanuel's ear when he was thinking about these issues, and I think it reinforced him in realizing that if there's too much confidentiality, there will be a backlash against it, and I think he was quite visionary in actually saying, well, let's make sure that in France this is not an issue for more trouble for arbitration, also in this respect. So it was just an observation. Thank you.
Thank you. So a comment, not a question. If there's any other comments or questions. Yes, up there.
Hello, my name is Monica Fernandez. I'm a Costa Rican lawyer based here in Paris. I did not know Professor Gaillard personally, but I think I speak for many when I say that to the extent I'm practicing arbitration today, we're in a way his intellectual children, if I may use the expression. So today has been an utter pleasure. Thank you to the organizers. I also don't really have a question, but I'd love to hear if there are views from the panel. It's more of a comment, and I wanted to go back to what was said about abuse of process. And Professor Schroer, you talked about non-disputing party interventions and how sometimes the home state actually agrees with the respondent and not the claimant. And I know a little bit the CAFTA context, which has precisely a non-disputing party submission provision, and a very rich experience here. And I think it's a very interesting phenomenon, and I think the question of is it a subsequent agreement or is it a subsequent practice? What does this mean under the Vienna Convention? I think that's all fascinating. I would really hesitate, with a lot of respect, to put it in the same basket as other so-called guerrilla tactics or abuse in process phenomenon like what we have said earlier. So I just wanted to add that to the discussion. And thank you again, and thank you to the panelists.
Thank you, Monica. I don't know if there's any wish from the panel to make any additional comments.
I would just say, when I was at the State Department on the NAFTA arbitration team, we dealt with these matters because of Article 1128 of NAFTA, and I think one of the dangers, I'll just say, is the reintroduction of that particular political element. So you've definitely got the claimant is aware of the possibility that these submissions could be made and certainly does not want the state to make a submission that would be against that claimant's interest. The responding party, the other state, is also aware of the potential power of these submissions, and of course wants a submission on its behalf or consistent with its position. I mean, maybe there's some benefit in that there are these two competing elements often. I mean, but what that means is the state says nothing sometimes. Is that because because of that, because of those considerations. But I think it's a little bit, it's a little bit hard, I think, for the state to be acting, I want to say, purely as a state and not as a potential litigant, either in that case or as a litigant in future cases, as it is thinking about how this statement might be used against it in future or in favor of it in future. So it's a tricky business when you have the state fulfilling those two roles.
Thank you, Andrea. Any other thoughts? No? Any questions still from the room? Yes.
Oui, bonjour, Jean-Marc Elsols, du cabinet Sherman Sterling. Voilà, je voudrais finir avec une anecdote et vous parler d'un véhicule qui s'est fait arrêter à San Francisco en début de semaine. Je ne sais pas si vous avez entendu cette nouvelle ou est-ce une légende urbaine. En tout état de cause, ce véhicule roulait tout feu éteint et a donc été en pleine nuit et donc a été arrêté par la police. Le véhicule a initié on va dire un comportement complexe pour se soumettre à la loi et donc répondre à l'injonction policière. Et lorsque les policiers ont ouvert la portière, ils ont constaté qu'il n'y avait personne dans le véhicule. Que le véhicule était de marque Cruise, alors je ne suis pas du tout un employé de Cruise, mais de marque Cruise, roulait de manière totalement automatique et avait en lui ce qu'on appelle une embedded regulation, c'est-à-dire qu'il avait une réglementation embarquée qui lui permettait de répondre y compris à une injonction policière. Alors, quel est le rapport avec le sujet? Le sujet, c'est la question de la confidentialité des sentences arbitrales. Et ça, nous en avions discuté avec Emmanuel, puisqu'il était intervenu il y a 2 ans dans un colloque sur l'intelligence artificielle. Et l'un des points certainement sur lequel vous devrez réfléchir, et franchement ça ne viendra pas de moi, mais c'est juste une observation, c'est sur le fait justement de pouvoir en tout cas faire entrer les sentences arbitrales dans des process d'intelligence artificielle, puisque ce qu'on a vu en début de cette semaine est tellement étonnant, inattendu, et je veux dire, il y a encore 2 ans, lors du colloque, est-ce qu'on aurait vraiment pensé que cette anecdote puisse être possible? Donc c'est juste pour signifier qu'il y a une évolution à prendre pour que l'arbitrage puisse s'adapter certainement aux process qui vont venir concernant l'intelligence artificielle. Voilà.
Merci Jean-Marc pour cette observation. And if there's no other questions or comment, thank you very much. There's one here, yes.
It's more of a comment than a question, but it's a comment on which I'd appreciate the panel's thoughts. Sort of seeing the different topics that were chosen, and there is sort of a continuum. If one looks at investment arbitration as a system, and if one analyzes it, as Professor Gabrielle Kaufmann-Kohler was saying, from the lens of a practitioner, but as Jacques Pellerin was saying, with the idea that thought needs to be useful, there was a problem. You have a problem of multiplicity but a problem born out of treaties that allow for indirect shareholding, allowing shareholders at different levels of a shareholding chain, each with its own forum and recourse, but all arising from the same facts and laws. And then the abusive process is as Professor Schroer said, is certainly a principle of law, but its manifestation here is as a fix to this problem in the system. The system had to change. Another related one, in which Emmanuel also had a big hand, is res judicata. It's the other end of the spectrum, or waivers. So you've had the decisions in Ampal, for example, where a minority shareholder is held to be bound by any defense available against the investment vehicle, including res judicata, so collateral estoppel. And interestingly, here it's a minority shareholder, so unlike other cases, RSM or Apotex, it's not a majority shareholder, because the basis is not controlled. The basis is, again, the system has to work, and for it to work, if you're allowed to claim reflective loss, looking through a company, you have to be bound by the defenses available against that company. And to me, that sort of case law fits rightly in with the case law on abusive process and is a necessary fix for the system to work until you reach sort of new generation of treaties that now more rightly and clearly set out coordination of claims in this sort of chain of shareholding. That was the comment.
Thank you. And reflective loss and shareholder claim was one of the next topics that Emmanuel wanted to tackle in his writings. Well, we will have to continue for him. Any other questions or comments? No. So this panel, I do want to thank each and every one of our panelists. It's been a real treat. Gabrielle, thank you for being with us. Thank you for allowing us to remember Emmanuel. Thank you for coming from Geneva for this event. I'm very touched personally. Thank you to Andrea for coming all the way from McGill in Canada and also for being with us. Thank you, Christophe, for at the last minute stepping in Michael Reisman's shoes, who unfortunately could not be with us, but for your thoughts and for your considerations. And thank you, Julien, for many, many things and for your wonderful thoughts as well. This panel wanted to finish by each of our panelists to say a few words, maybe more personal, maybe more generic and more general on Emmanuel's contributions and influence on investment arbitration and beyond. So we will finish with that, and starting with Gabrielle.
Thank you. And you thank me for being here, but thank you for inviting me, because it is truly a privilege to be here to pay tribute to Emmanuel. Rereading some of Emmanuel's writings over these last days was like a wonderful journey. It was also somewhat of a nostalgic journey because of the force of the circumstances, but it was a journey retracing the evolution of investment arbitration from the very start. And we could have discussed many more topics, but that would have been very interesting as well. But that is what we chose. And throughout this journey, I was struck, I did mention it before, by a consistent pattern of Emmanuel's work, combining in the most effective way his practice and his scholarship. Often confronted with an issue in practice, he was then facing it later as a scholar and making sense of it. He would then frame the issue, map out what was available, but more importantly, he would carry further and enumerate the possible remedies to find solutions. And he would then assess the remedies and show the way forward. And I think that is one of his major contributions. In this fashion, he addressed most of the hot issues of investment arbitration. In addition, in the Chronique, he provided systematic analysis of case law for many years, and then through conferences that he organized together with Yas, who of course has credit for some of this in her own right. He induced others to reflection and on new novel issues. And for all this and more, for his formidable legacy, he will be long remembered with sympathy and admiration.
Merci, Gabrielle. Julien?
I will do a mix of personal and arbitration, but I have to start with a preliminary point. Emmanuel and Yas were actually the first person I've ever worked with in international arbitration. I was an intern in Maîtrise at that point in time that still existed. And Yas always said that I was also her first public international law intern, so it was a first for both of us, so that's a good thing. So I'm beyond honored to have been able to sit here today on this panel and to discuss what Emmanuel's thinking has brought to international investment arbitration and investment law as a whole. I still remember very vividly the first encounter I had with Emmanuel, and it was in a meeting room. It was in 2000. Meeting room at Journée selling one of those round meeting rooms, where he would sit for days drafting his famous Chronique au Clunet. And he just called me up because he needed some help with part research and part translations, and that's when we connected for the first time. And why am I mentioning that? It's because for me, this, not only because it was my first encounter, so it's close to my heart, but because for me, this chronique au Clunet is the paradigm of Emmanuel's influence, not only in France, but in general with respect to international investment law. Indeed, teaching and explaining, as Gabrielle said, since 1986, what ICSID was and what this new arbitration venture would be, seemed crazy. Very few saw it as a promising field. But he is one of the very few that discovered investment arbitration in France, the one who methodically and for almost a quarter of a century built an analysis of what he later called, probably as we know him a little mischievously, la jurisprudence du CRD, which caused some teeth grinding by some of his fellow law professors that could not accept that there should be an arbitral case law, jurisprudence arbitrale. And he did it in French, whereas it would have been probably way much easier to do it in English and would have attracted a wider audience. Because as I imagine it, it was going along his willingness to present investment arbitration not as a secret or a mythical animal, but rather in a transparent and open way. This chronique allowed thousands of practitioners to have access to a jurisprudence in French where they actually not necessarily able to understand what was written in English. And again, it started in 1986. And finally, I must say that contrary to some other, as we've discussed previously, it was also his courage to express, state, and say, and take a position and a stance on topics that were extremely hot topics, be it for the umbrella clause, as we have discussed, or for the role of international law in Article 42 of the ICSID Convention. And this was of paramount importance for the development of international investment law. Taking a stance not because you have defended a position for a client or sitting as an arbitrator, but because for the brilliant legal mind that he was, he believed that doctrinal positions were important to shape the international investment law and arbitral legal order in the making, or actually made already. Et je vais repasser au français, juste pour une anecdote. Et pour clôturer ce que j'avais à vous dire. Je suis toujours resté en contact avec Yas et avec Emmanuel depuis que je suis parti, et je les ai toujours consultés quand j'ai changé de cabinet de nombreuses fois, et quand j'avais des projets d'écriture. Et j'allais généralement voir Yas et Emmanuel, et je rentrais toujours dans le bureau d'Emmanuel, et je l'entendais toujours me dire, il me disait toujours « Salut mec, quand est-ce qu'on l'a fait cette partie de squash ?» Parce qu'on se croisait tous les dimanches matins dans la salle de squash. Donc, à moi de te dire aujourd'hui, je ne te dirai pas salut mec parce que je ne pourrai jamais te dire salut mec, salut Emmanuel, j'espère que nous te rendrons fiers, j'espère que nous défendrons ta pensée et que tu nous as légué et que nous chérirons, et je te promets qu'on la fera cette partie de squash.
Merci Julien. Andrea?
So I guess I too will have a mix of maybe personal reminiscence and just words of appreciation. So I remember the first time I met Emmanuel was in 2005. It was in The Hague at a conference, a book launch conference. And what I remember most is that I gave what I did not regard as a particularly successful talk. But at lunchtime in the basement of the Peace Palace, he came up to me, and I was sitting at a table with several other people, and he said, "Thank you, I very much enjoyed your talk. I think I agreed with everything you said." And as a young academic, it meant the world to me that he would have agreed with what I said, but more than that, that he made the effort to come to talk to me, to say something kind. And that was, that's meaningful, and it's something that I've tried to remember and to, if you will, pass on, that sometimes those words of kindness can mean a lot to, maybe especially to junior academics, but perhaps to senior academics as well. People always like to hear nice things. He also took the time and the effort to send me La Jurisprudence du CRD. So he sent that to me in California. And again, I was quite impressed that with his follow-through, right? He didn't just say that he would do it. He actually did it once he got back to Paris. So I remember, I remember every time that I ever met Emmanuel, and often Yaz with Emmanuel. So I have these, I won't go through all of the episodes with you, but I was just to say a word about his vision and his breadth. I remember a conference at Columbia where we had a panel on the then, say, hot topic of the Argentine cases and the defense of necessity and the different strands of jurisprudence about how the Article 11 of the US-Argentina treaties clause intersected with the customary international law defense of necessity. So after an hour and a half of, of toying with these different issues, Emmanuel gave a kind of a closing comment and said, we've spent an hour and a half on this particular very, very small topic. What hasn't come up is the fact that in every single one of the Argentine cases, Argentina lost on fair and equitable treatment grounds. There's a remarkable line of consistency in those cases that nobody talks about, that it hasn't captured kind of the public attention. And, but it captured his attention, and he made that intervention. And, maybe it sounds relatively simple to talk about that here, but the ability to move back and forth from the most granular level of analysis to take a really broad systemic view and to go back and to go back again, I think is quite remarkable and rather rare. And he really possessed it in a quite extraordinary way. One of the things that just to close, to bring things back to Montreal and McGill, there was a conference, I believe it was in 2009, for the Institut d'Arbitrage International. Gabrielle and I spoke on the same panel about transparency in investment arbitration, as a matter of fact. But one of the things, and so Emmanuel and Fred Bachand and Yaz invited me to take part in that panel, and I have to say that was a life-changing experience, because one of the things that happened at that event was that at dinner I sat next to the professor at McGill who was chair of the hiring committee, and who later on called me and invited me to apply for a chair at McGill. And lo and behold, I moved to Montreal. And while that might seem a little bit tangential, I always think of Yaz and Emmanuel when I go up to the common room where we had a grand cocktail at that event. And I attribute a lot of my current happiness in my professional home to them. So I thank you very much for the invitation to be here, and thank you all.
Thank you, Andrea. Christophe, you're the last.
I will be quite short. I have always admired Emmanuel for his enormous versatility and manifold talents. He was a leading academic and thinker. He was an accomplished practitioner as an arbitrator and as an advocate. And he was a brilliant organizer of conferences, of symposia. He created institutions, the Arbitration Academy, to name just one. I think he will always remain an outstanding role model for all of us. Thank you.
Thank you, Christophe. Please join me to thank our wonderful panelists. Je repasse au français pour clore cette journée, peut-être sur la très belle image d'Emmanuel qu'on voulait partager avec vous, son sourire, son charme et sa bienveillance. Merci à ma complice, Marie-Élodie Ancel. Merci à toutes les organisations et ceux qui la représentaient, Dominique Hacher, Jacques Pellerin qui n'est plus là, Pierre Myres, J'en oublie sûrement, Yves Daudet, Catherine Kessedjian. On a tous ensemble travaillé pour ce programme riche, fertile, comme Jacques Pellerin aimait à le souligner ce matin, pour ne montrer que des facettes en fait de ce que Emmanuel nous a légué comme praticien, comme théoricien, comme arbitre, comme ami, comme mentor et d'autres qualités encore. Et donc je voudrais juste finir sur cette note en disant, comme on l'a entendu tout au long de cette journée, on espère tous être à la hauteur de ce qu'il nous lègue. Merci à vous tous d'avoir été là aujourd'hui avec nous. Merci à vous tous encore qui êtes là à cette heure tardive. C'est un honneur que vous nous faites. C'est un très bel hommage à la mémoire d'Emmanuel. Et on va tous poursuivre, j'espère, son œuvre qui est riche et fertile. Et j'espère vous revoir encore longtemps et discuter encore longtemps de cette très très belle question. Merci à tous.